Does a witness's drug use or alcoholism make their statement unusable? I got a question from a client recently that I hear all the time. If a witness is an alcoholic or a drug addict or has priors, does that mean that their statement can't be used? In court, there's a really important distinction between weight and admissibility. Admissibility is based on the rules of evidence, and it is about whether the evidence is allowed to come into court at all. Weight is about how the judge or the jury perceives that evidence and how much weight or value they should give to that evidence. Most of the time, the witness's statement is not going to get thrown out just because they're a drug addict or they have a substance abuse problem. Don't get me wrong, that doesn't mean that their substance abuse is irrelevant. It usually goes to credibility. In other words, how reliable is this witness? Was the person intoxicated at the time of the event? Were they using drugs or alcohol when they perceived what they're talking about or when they made the original statement? Do their substance abuse or drug use problems cause memory issues? Are there inconsistencies between what they said then and now? Those are the kind of questions that are going to matter with a witness that might have credibility issues as a result of substance abuse, drug addiction, or some other fact that might make them unreliable. The state still has the burden to prove its case with reliable evidence, always. So, yes, substance abuse problems can seriously weaken a witness's testimony, especially if their perception, their memory, or their ability to accurately observe what happened is questionable. Other times, it may not matter much at all, especially if there's independent evidence that backs up what they said. This is where having an experienced defense attorney matters. We don't just ask, can this statement come in? We ask, how much weight should it carry? And how do we expose the weaknesses in the witness's reliability and credibility based on those substance abuse issues or based on anything else that might make their testimony questionable or less reliable? So, no, there's no automatic rule that says a witness's statement is unusable just because of drugs or alcohol. But it can absolutely affect how believable that statement is. And that can make a huge difference in how the case is resolved. If you're facing criminal charges and witness credibility is an issue, that's something you should talk with your attorney about very early on. We do criminal defense representation in Tucson, Pima County, and surrounding areas. So if you're facing criminal charges in Tucson, give us a holler. And if you just want to learn more about Arizona law and how it works, give me a follow and let me know if there's anything else you want me to explain or talk about.